And, well, welcome to tonight's Asset Protection webinar with Stephen Sumption. My name is Don Pendleton. I'll be your host and MC, and thank you for putting up with our technical difficulties. We're excited about this webinar. This has been a very, very long time coming. We've had so many experiences on our asset protection hotline over 15 years where just absolute horror stories of people who were legally structured right, but when they went to sell the business or when they went to purchase a business, didn't matter the legal structure that they had, that the contract that they had to buy and sell their business was faulty, and just absolute horror stories. So we've got an expert with us to talk about the legal pitfalls of buying and selling your business. Before we get into that, let's do just a couple things of housekeeping. As most of you know, unless you're brand new, this is a part of a webinar series. We're normally teaching 2 to 3 webinars per month. And so, I don't know, a couple months ago we had Kwame Granderson on raising capital for real estate deals. Kwame was top of his class, Harvard Law School. Since he's come out of school, he's raised billions of dollars in venture capital. So he's not only an expert in raising capital, but he's also an expert in legal structuring and what you have to do if you're using other people's money. We can't just use a standard LLC or a standard limited partnership. It needs to include clauses in there that are approved by the because we're doing things with other people's money. It's very, very different. And so a lot of our students have got into trouble, and so he very bluntly talked about that. Nick Palavita talked about defined pension plans as maybe an ultimate asset protection tool because of the federal laws that protect defined pension plans. We had Scott Estel on a week before tax season talking about last-minute tax tips. Those of you that may not know, Scott was a former senior trial attorney with the IRS, and since he's been out of that, he's defended close to 2,000 people in tax court, all the way up to the Supreme Court level of the tax code, brilliant at the tax game and what works and how far to push the IRS, how far and when to back down. Kevin Clayson was on last week. And then, you know, tonight we've got Stephen Sumption. Barry Siegel will be on next week, next Wednesday night, eligibility for veterans benefits. Then we've got Howard Neuenswander talking about when it makes sense to do offshore planning. And if we're going to do it, how to do it IRS compliant. I'll be on in a couple weeks talking about some of the ethical issues of asset protection. When asset protection becomes fraudulent, how far we can push. Can we do lawsuit protection right in the middle of a lawsuit? Sometimes we can, and sometimes it would be fraudulent to proceed. And so we'll talk about those issues. For those of you that, again, that may be new, we do record all of our webinars, and we keep them free for about 30 days. After that, they go into the archive. Those archives are available, and we've got a huge library of different subjects that are asset protection related. Again, if you're getting our emails or if you've signed up for a free membership, you will always get access to the live webinars. We want you to do that. We want you to go back and listen to the recordings. However, the archives, it's $129 for a 12-month unlimited access. You can review those and replay them as often as you'd like. It's a huge library and tremendous information. We encourage you to join us if you're inclined to do so at assetfoundation.com or assetprotectionacademy.com. We also have 3 asset protection summits coming up in the near future. In June, we're in Chicago. We're about 5 weeks out from that, so if you'd like to join us, please register at assetfoundation.com or assetprotectionacademy.com. We've got one coming up in Charlotte, as you can see on your screen, or Las Vegas in November. And so we're excited about those. At the 3-day summits is we're bringing in some of the best of the best of the best attorneys. Certainly not everyone we've had on our webinar series, but some of the best speakers and attorneys, and with backgrounds that are just knock your socks off. So we encourage you to join us at a summit. At the summit is also a time when you get to sit down one-on-one and talk about asset protection, not from a theoretical standpoint, but sit down with an attorney and let them go over your estate, ask them blunt questions, training questions, specific questions, whatever you'd like to ask them while you're at the summit. That would be your opportunity to do that. The tuition for that, if you're looking for continuing education credit, is $995. Our regular tuition is $199. If you've got an asset protection kit, or if you're coming in as a guest, let's say of the Assumption Law Group or another law group that's supporting the Asset Protection Summit, then your tuition will be waived. And so we hope you'll be able to join us. And then last little bit before we turn the time over to Steve, just a legal disclaimer. Anytime we're talking tax or legal issues, know that we can teach them from a theoretical standpoint in a webinar setting. In a webinar when we've got potentially hundreds of people on and we'll record it and put it on the archive, know that we can teach theory, but how that applies to you in your specific case is always an issue for maybe you and a qualified attorney to go over. And so we hope that makes sense to everyone. There's the official legal disclaimer. Again, this is asset protection, so we hope that you understand that. So with that, let's talk about legal pitfalls of buying and selling a business. And so I'm not going to spend a lot of time. Steve, I'm going to let you kind of give a little of your background. I will just tell you how delighted I am to have you. I was so excited about your presentation this afternoon, and look forward to repeating that. Know that as soon as the presentation is over, and he's going to take a little bit more time, there will be lots of time for question and answers. And the way you'll do that is simply type in your chat, in your chat screen, the question that you have. Try to be as clear as you can. I'll probably come back on. I'll mute myself while he's presenting. I'll come back on, read the questions, and we'll kind of bat them around a little bit. So Steve, without any further ado, we're delighted to have you. Thank you, and we're going to turn the time over to you.
Thank you, Don. It's been a pleasure to work with you over the past month or two. Don and his staff, Kendall, and the three of us have sat down to talk about some of the business needs of the Asset Protection Academy attendees. And I'm delighted to be able to share some highlights from the past almost 30 years of practicing law. I graduated from Brigham Young University Law School and then went to Washington, D.C. to work for a federal judge for a year. And basically my career is split 50-50 between corporate practice and private practice. I went straight to IBM and a competitor IBM for 10 years, and then some mid-sized companies. And then I took a 2-year trip with my wife and 7 children and moved to the Republic of China, commonly known as Taiwan, and worked almost like in-house counsel for Citibank and other large banks in doing high-end financial transactional work. Since then, I've been back in Utah handling a variety of business cases, both transactional and litigation. But it's kind of unusual for a lawyer to go from in-house for half his career and then go into private practice. But we have a staff of 7, 4 lawyers, 3 assistants, and I'm delighted to be able to talk about legal pitfalls in buying or selling company, because those of you out there that are listening want to have an exit strategy. This is really quite fun to have a variety of businesses come in the technology or construction or dental, just a whole variety of businesses, and learn about them. I'd like to hit these points very quickly because I want to get into some meat. The war story will highlight some of these points about an asset purchase versus stock purchase. You may hear Wall Street news about big stock purchase transaction, but frankly, on the small to medium-sized businesses, an asset purchase tends to be the more common approach. Certainly, if you're going to be buying the business, you want to consider whether to have an appraiser. I don't know what your experience is, but I notice that an appraiser will generally be conservative, need to back all of the analysis with a more conservative approach. So if you are buying a business and have concerns about what would be fair value, it would be wise to consider an appraisal. Many of you may know that there are 4 different certified levels, and depending on the size of the business, you can structure it to fit so that really it creates a point of negotiation more than an absolute, unless you're in a buy-sell, forced buy or sell situation that you may be bound to go through that process. So the big consideration there at the bottom about considering seller financing brings a whole host of issues that we'll talk about in our examples. And escrowing a portion of the purchase price is certainly an option as well. But let's get into some meat here with how one can protect a buyer. Let's take this example here. It's fairly similar to what I see many professionals, whether they're a dentist or a doctor or an engineer. They may have a list of clients that they want to protect, and they built up that goodwill with those clients. How portable is that to a prospective buyer? In this particular case, it was a dental lab doing crowns and other molding. Had a very loyal clientele, but let me tell you how it went awry. I represented the dental lab that was purchasing this smaller dental lab's loyal clientele. And before the seller was able to get counsel involved, we were able to structure the deal. And I would submit that the highest value of legal services I provide is typically in the structuring aspect. Many of you are seasoned businessmen and you feel like you got that covered, but when we talk about some of the items in this call, I think you may be in a position to recognize that counsel can help you structure it, and before things get too far down the road, it's important to consider such things as what did not happen in this case before opposing counsel got involved. We did have references to obligations to make certain payments, but there was no personal guarantee or promissory note that was at play. Instead, we were able to, the buyer was able to rely on some language in the covenant section of the agreement to argue that payments would legitimately stop because of a failure to make a smooth transition of the loyal clientele to my client, the buyer. Ultimately, my client was able to cease payments after the seller failed to transition the loyal clientele that he had over to mine. So fortunately, there was not a personal guarantee that required my client to pay nonetheless. And so we can learn from this experience that it is very important to structure the deal properly and consider bringing counsel in to help with that. In that case, it certainly saved my client a lot of personal liability. So when we're buying a business, here are some items that I'll just go through very quickly. Certainly the articles of organization and operating agreements and basic monthly reports or quarterly reports of the financial information. And obviously the smaller the company, the less reliable and controls there may be in place. And you want time to review obviously the physical assets, whether or not to purchase the real estate. Don pointed out to me after the discussion we had this morning that some of the more sophisticated businesses will keep the real estate separate in a separate LLC, and understanding what obligations or opportunities there are with that is important. Intellectual property is a trickier area to ensure that you receive the bundle of rights, whether it's trademark, copyright, or even patents. We want to be especially careful with intellectual property. Whether you're going to transition employees over, licenses and permits may need to be sought and obtained with certain requirements that can take time and additional money. Certainly, you may be familiar with the strict liability of environmental issues that can make hazardous waste a very significant concern. Taxes and material contracts, really that is one of the most important areas in buying a smaller business. Very frequently, in my experience, the clients and customers are the ultimate assets and goodwill of the business, and whether those contracts have termination provisions with a simple notice that for any reason a customer wants to move on, that would create a significant problem being able to bring that client over. And so we want to understand what the vendor contracts say, as well as, most importantly, the customer contracts. Insurance is an important consideration for purposes of key man insurance, transitioning automobile insurance, commercial general liability. All need to be evaluated before you make an ultimate commitment. Now, let's talk about an instance that caused a particularly great deal of pain to a PhD and a professor at a well-known, well-established university. This client came to me after he purchased a dietary supplement business that was struggling. And his background led him to have the confidence to put together a 3-page agreement that, honestly, there were terms of that agreement that I felt a layperson had, or for a competent business person put together, that would on its face appear to be adequate. The problem, however, is that it was incomplete, particularly with regard to intellectual property rights. More specifically, trademark and non-compete clauses. What happened is the founder re-entered the dietary supplement industry with identical, very, very similar product, and he tried successfully to use the same trademarks that he arguably had sold to my client before he was a client. The founder, the adverse party, claimed intellectual property infringement, even though the terms of that 3-page document put together, from a lay perspective, had the bundle of rights, the right to use all marketing materials, which included the trademarks that founder was who he had considered them to be infringing. Well, after 2 years of litigation, the cost of that litigation, coupled with the loss of sales, resulted in a very unfortunate business situation that could have been overcome with a proper complete documentation, particularly in the IP category. It just is amazing how much devil there is in the details, and particularly with regard to intellectual property. So if you're buying a business, here are some of the more common agreements that we have found very useful. The first one is a letter of intent that I'm actually negotiating one right now, and the issue is whether we make it binding or not, and there are merits for doing both. I think it certainly makes sense to create a letter of intent so those terms are laid out, but whether or not it's binding may be something more important for the buyer of the business, because there's a desire to lock down certain terms and throw in a clause that would prevent the seller from shopping the price around to find a better deal. Almost like a real estate purchase contract, an option contract. So it's really a unilateral binding letter of intent that could be used very effectively for a buyer. Confidentiality and non-circumvent agreements are really very simple documents that can be used to protect situations when you as a businessman, whether you're buying a business or selling a business, or if you're simply engaging in preliminary discussions with a third party to see whether or not you want to use someone's services and want to make sure that the other party doesn't go around you and take advantage of the information that you share. Very valuable. The asset purchase agreement really becomes more frequently used in the smaller businesses. Why? Because it allows you as a buyer to distance yourself from the prior conduct of the seller of the business, whether it's creditors that would make claims for amounts that you may not be aware of, or injury caused by products or services. You have a much stronger position to disclaim liability for prior conduct if you work an asset purchase agreement. One of the documents that are particularly important, I think, for the purchaser of a business is a consulting, employment, or non-compete agreement. They can be blended together into one, but this is particularly important to ensure that when you buy the business, that seller doesn't then go out and recreate business and take away your customers. I now have a client that now has 300 employees, and he has started, sold, waited out a 5-year non-compete, started, sold, waited out. He's done this 3 times, and he's about 60 years old, and he has made a lot of money. And you would say, well, why didn't they make that 5-year non-compete into 10 years. And the reason is because courts are loath to enforce a non-compete for that long period of time. But there are circumstances where other clients have insisted on longer, but they risk the enforceability of that because the non-compete will be evaluated for fairness or for reasonability with regard to 3 factors. 1, reasonable time, which 2 to 5 years is 2 years is a pretty safe category. Then you have geography, frequently the United States. In a more narrow, like a dental or professional, it would be a certain number of miles radius. Or the third prong is the scope of services, for example, providing pediatric services within that scope, that particular area. Now let's go to certain clauses that can be very important when you are selling the business. So we're going to change hats here. As you noted at the beginning of the presentation, we talked about the significance of buying versus selling. So if I'm representing a seller, and I just got off the phone an hour ago suggesting to opposing counsel that with regard to my client who is going to sell his interest in the business, I want to draft the promissory note. I want to consider a confession of judgment. That may be the most foreign term to you. Basically, what the confession of judgment does is allows the parties to sign documents that can more quickly facilitate a judgment from the court rather than going through the whole discovery process that is very costly. The smaller the deal, the more important it becomes to have a confession of judgment. Personal guarantees from, for example, a spouse is something to consider, particularly if you're selling a business and not getting all of the money, which usually doesn't happen in small businesses. There's a portion held back. And to request an interest clause for the unpaid portion of at least 1%, that should say 2% per month. I think it's not unreasonable when a seller sells a business and, depending on the amount of security and the length of time, I would not be uncomfortable negotiating a 2% per month clause, because the notion here is that you want that interest rate to be higher than whatever they're paying for other lines of credit. Attorney fee clause has been an absolutely critical clause for me to get involved in many cases in enforcing these kind of transactional documents when things go awry. The smaller the deal, the more important the attorney fee clause is, because there needs to be a consideration for the time and effort associated with what in many cases can be a very contemptuous, emotionally drawn out litigation that you want to be able to rely on a good attorney fee clause. In fact, in my experience, sometimes the attorney's fees significantly exceed the ultimate amount that the principal amount that we win at trial. Of course, all of these clauses and agreements have really little value if we don't have all the appropriate parties, and asking for spouses to sign off when a business is when you're doing seller financing is not unreasonable. Okay, here is a classic example of a very smart, aggressive, successful president of a company that was minority shareholder. He sold his interest back to the principal and formed his own competing business by mutual agreement. The deal was that the clientele were going to be split up between them, and then $1 million would be paid back for the right to that, the clients that were being taken by my client, the president. What happened? The buyer, the buyer company, the buyer of my client's interest, ended up competing and taking some of the clients that were my clients, and my client argued that because there was that violation of the terms of the agreement, he had a right to stop making monthly payments. The question was that violation of the non-compete significant enough or material enough to justify that? The other key question was whether the promissory note that was signed by both husband and wife had qualifying or conditional language in it that opened the door to a claim that the LLC or the buyer's violation of the non-compete excused my client's non-performance of paying the monthly payments toward the $1 million note that was over 4 or 5 years. Well, after 2 years of litigation, various motions, and all the discovery and the detailed combined total of $500,000 in legal fees, but it ultimately resulted in a settlement of a fraction of my client having to pay toward the $1 million, the original obligation, which resulted in a huge loss to the party, the company that bought my client's interest. So what do we learn from this? It's very important in the promissory note to not have qualifying language. It's very important to make sure that the obligations, what we call covenants, of what agreement there is to not compete are abided by. Otherwise, you risk non-payment. As we look at this president now, it's very interesting to me to see that he has become an industry leader and has far exceeded his former employer's success. He was definitely a rising star. Okay, so if you're selling a business, let's consider these elements in your contract. Assuming you're going to take, if you're going to consider seller financing, you want to have security and collateral for any unpaid portion. What do you mean by that? Well, promissory note, confession of judgment, and we didn't talk about a UCC1 financing statement, but that basically puts the world on notice, and particularly banks, where if you're selling to a buyer who then has an obligation over 5, 6, 7 years to pay that, and if you don't have a UCC1 statement out there, you risk having another creditor or that buyer having other loans and obligations that would trump or take priority over the obligation to you. So the UCC1 provides notice and increases the chances that you'll get paid. The term of the non-compete we've spoken about has 3 prongs: time, geography, and scope. The list of inventory and assets included, not included, is just good business to document the deal properly, so that if you're keeping, for example, a car or a laptop or other aspects of the business that you're holding back, let's make sure we spell that out in the exhibit, identifying what assets go with the sale and which do not. Okay, the representation, warranties, and covenants of the seller and buyer is what you may consider legalese, but really creates the basis to allege breach in the event there is a violation of, for example, the covenant not to compete. So this right to retake the interest in the event of default is a situation where you as a seller are concerned that the security and collateral up here in the first item, let's say, for example, you have a promissory note, but if you're concerned that you may need to come back in to be able to help direct the company, you may want to negotiate certain terms that in the event of default you have the right to come back in as a controlling shareholder so that you can salvage the unpaid portion of the payments that are remaining. Here's an interesting story about a real estate brokerage that tried to avoid my client, the creditor, who had a $500,000 bill for services rendered to the real estate brokerage, which the brokerage thought they would play a little trick here. They thought, as you recall, back in 2008, a serious real estate crisis occurred, and they decided to restructure their company. This was a large brokerage that simply said, okay, we're going to change the owners of the LLC, and by doing that, we're going to have a new entity, new name of an LLC, but essentially they continued to sell houses under the same brand name. We argued that there was continuous liability and that even though they formed a new entity, they did not adequately document and separate the two entities, and we sued both entities successfully. And after filing a motion for summary judgment, we were able to come to a settlement. We found evidence that the new and the old entities were too similar, and the variety of factors that are considered there. But you want to be very careful when you continue to do essentially the same thing but want to move on with new partners and go a new direction. This is an area where you want to seek counsel. Now, in this case, my client, who was owed $500,000, ended up accepting a settlement over time that was secured with a promissory note, had a liquidated damages provision, a confession of judgment, and every payment came in just like clockwork before it was due because of the consequences. What is the moral of this story? Be careful how you structure a new entity, especially when the businesses are similar and the owners are similar. Let's go to another war story. This one is one of my favorites because this guy was so trusting. He built from the ground up a franchise that had stores around the nation. It was a restaurant business, and he thought he had it sold. He received payments on draft agreements for over a year. The problem is he didn't have an unconditional promise to pay. He didn't even have a signature. But what we successfully argued when payments stopped is that there was pure bogus claims about a breach of a covenant not to compete. There he had some red herring excuse for non-payment. And we argued that the promissory note, even though it was not signed, by operation of law, you may have heard that silence can be deemed acceptance. For a stronger reason, if silence can be acceptance, then having a promissory note that is acted upon for multiple months, making the payments consistent with that, created an obligation. And it did make it more difficult for us to argue that attorney's fees could be recovered. But ultimately, the complaint had to be filed to bring the buyer of the business back to negotiations. But just like the last example, we ended up putting together a promissory note, a confession of judgment, and he has continued to receive payments without any hiccup because of the security, the UCC1, all of these items, and the right to retake the business in the event there was in the event of a default. Oh, let's talk about a simple business split, because I think this may be a more common example where you and your partner may decide to go separate ways. We had one of these. They came in together, performed the same business service, and one wanted to retain the company, the other wanted to create a new company. They both had an interest in the ongoing accounts receivable. It really worked out smooth. They came to us. We put together a waiver of conflict of interest because it was such a simple deal. There was no carrying of debt and difficult negotiations to undergo. So we were able to prepare all the documents for the transaction, including the organizing documents for the new entity, and $1,800 did the job. The overall moral of the story with each of these 6 examples is that an ounce of prevention is worth a pound of cure. Let's look at a summary of some of the key points, and then we'll get to some of your hot questions. So start thinking of those now, if you would, please. In summary, we need to really think through and recognize the difference between buying and selling. As you can see, and if I could just refer back, in each of the cases that I was involved, there was senior counsel, more experienced than myself. And I cannot begin to count the number of times that there was issues that I could miss, but ultimately some very good firms miss some very important issues, and it's very tricky to think that you can buy a company and sell a company on the same terms. Maybe for small transactions that can work, but the bigger the deal, the more you'll want to have some careful review of the documentation to ensure you're adequately protected, especially as a seller. When with seller financing, you want to consider the 4 or 5 areas we talked about: the promissory note, the confession of judgment, spouses signing guarantees, UCC1, the right to retake. This type of security and these guarantees become critical in order for you to get your payments like clockwork. There's an important question, as in the covenants on the warranties and representations, as to whether breach of those will excuse payment. If you have a properly documented promise to pay, a promissory note, there's a very strong argument that can be made that whatever breach there is independent, and when there's a judgment, then maybe you can offset that. But the prevailing view is that if you have an unconditional promise to pay, as we talked about in the prior example, there is an obligation to make those payments notwithstanding a breach. And so these are very important considerations that a competent businessman may not pick up on. The assumption of liabilities, there are just so many that can be a problem that you may be aware of or have a hint of or have no clue. Intellectual property is a particularly sensitive area, and the non-compete kinds of questions that I get on a day-to-day basis are significant. But let me tell you the bottom line on non-compete, what I've learned over almost 30 years. That is that if you want to enforce a non-compete, at least in the state of Utah, the primary two questions. What the judge has turned to me and said, tell me what is confidential or is protected by trade secrets, and what are the damages. So this notion that you can stop someone from pursuing their profession is not going to be well accepted by the courts. They frown on stopping, say, for example, a vice president of sales that wants to move over to a competitor. As long as he doesn't take confidential information that would damage the prior employer, that kind of non-compete may be very difficult. In a buy-sell agreement, however, someone who says, I will not form a competing business, you're going to have a much greater degree of success with enforcing that kind of non-compete. Remember the due diligence checklist we had at the beginning? Let's consider those. Now, here is a quick one. I want to go through this really fast to just reinforce what Don and the Asset Protection Academy may have said in words, but I really like this little chart. Let me point out a few things just in summary here. What's your favorite entity? Time and time again, I really end up with this limited liability company being my favorite. Why? It arguably is just as strong as a corporation on liability. Tax-wise, your double taxation problem with a corporation is a real negative. Flexibility, oh my goodness, I just had a client that came in 2 weeks ago that we're trying to negotiate right now a problem with a technicality of 2 board members out of 4 voted to terminate the founder and CEO of my client. It's the most outrageous abuse of power, but they have an argument, and rather than fight, he's willing to sell out, and we're now negotiating an opportunity for him to sell 25% of the business that he started and generously gave to others, and they turned around and stabbed him in the back. So I really prefer proprietorship is out just a very poor way. I think you can make strong arguments for a limited partnership, but the limited liability company with formalities being so flexible is really my preferred entity for small business. That's a little background on me, and I appreciate the opportunity. Let's get to some hot questions.
All right, Steve, thank you very, very much. And we've got on the screen, if somebody's interested in contacting you, looks like your information is there. For those of you that are just listening in, I've got a phone number of 801-375-2830, or they could contact you at steve@businesslawutah.com. We'll come back to that a couple times if you're just listening in. Steve, while we're waiting for questions to come in, and listeners, if you'll type in your little chat room, a little chat screen, any questions that you have. I don't see any coming in yet. Let me tell you a quick little story, and maybe you can. I was vice president of legal and compliance for a company that was doing about $300 million in sales, and they wanted to. The owners were tired, and they had been doing business for 25 years, and they wanted to sell, and so they, in the due diligence process, they brought in a company from New York. And one of our attorneys in Salt Lake prepared the documents that would allow them to come in and look at all the company, and treat everything as confidential. However, he used one clause that should have been used. I think that the buyers, had he been representing a buyer, it would have been a very attractive clause, and that was anything that's in the due diligence process that is not marked as confidential will be treated. It won't be treated as confidential. Well, unfortunately, he was representing us, the seller, and that clause in there that said anything that's not marked as confidential will not be treated as confidential. It will be treated as common knowledge. We gave them boxes and boxes of information. We gave it all to our attorney first, who then failed to mark every page as confidential. We had on there our vendors, we had our contracts, we had our marketing pieces, our whole customer list. We had our accounting practices, our books, our pending litigation, trade secrets, intellectual property, everything we owned was in those boxes. The company from New York looked at all of our stuff. They looked at the agreement that they had signed. They backed out of the deal, and within 2 weeks they were competing head-to-head with us. And when we asked them why, they said, because you said you could. And it was it was like, it was so hard to backtrack at that point. And there was a lawsuit that commenced for 1.5 years, but we didn't prevail in that because our attorneys had prepared that they didn't understand the difference. Just like you were saying, there is a huge difference in a contract whether you're the buyer or the seller. Steve, I've got lots of horror stories to tell you, but that was a $300 million company went down the tubes because the wrong agreement was prepared. All right, so with that, let's take some questions, and let me read those. Steve, any comments on that? That can't be your biggest horror story. You've got to seen bigger ones than that. But
no, that's
any others.
Yeah, that's a great example of where the business partner is not in sync with, or the lawyer is not in sync with the business partner, and so this becomes really critical. That problem could have been solved very easily just by simply, when the documents are sent over, putting, nowadays we put those documents, instead of boxes, preferably would send them in a PDF file, and we would put a notation on it that is confidential, but we have what's called bait stamping documents, and just putting that label on it would have solved the problem, but I think there could have been other potential cures of that. But there are cases that say that when, 3 ways to find confidential. One is if you label it. 2, if you know, or if it's common knowledge that it really should be confidential. There are courts that have concluded that expectation of privacy and the just knowing that it had some very sensitive information, that would be enough to deem it confidential. And so I think had that case gone all the way to trial, if there were, again, back to the 2 prongs that I mentioned earlier, did it cause damage? If someone went and actually stole those customers of the business based on that knowledge, and there was not an independent way of finding that information, I would argue that I would submit that a judge may very well find that to be confidential, and damages would flow.
And you know what? There came a point where it was costing way too much, and the damage had been done, and both businesses, it was just an absolute nightmare, and I think we could have prevailed had we taken it all the way to trial. But anyway, let's get on with questions. Hi, thank you. Can you explain a little bit more about confession of judgment, and are you saying UCC1 helps you get paid over other creditors? Thank you. Great question. Thank you.
That is good. UCC1 is similar throughout the United States, and the notion is that the obligation to make a payment under, for example, a promissory note, that there's a record out there, almost like a debt or a judgment, that when banks, before they will loan money, will check the records to see whether there are significant obligations already out from that party. And so it creates a notice such that the bank likely will have second thoughts before they lend money, because that acts as what we lawyers refer to as perfecting a security interest and giving priority over the prior party, you as the seller who is providing seller financing. So it's an important tool that banks use all the time. Equipment leases, very commonly used, but perhaps not an item that many of you have heard about. Now, with respect to the confession of judgment, this is even a more narrowly used pleading, if you will. It's 2, 3, or 4 pages long. It basically identifies the obligations that mirror or very similar to the obligations under the promissory note. And it's signed. It's a document that is signed by the obligor, and basically they are saying, look, if I don't make a payment consistent with the terms of the promissory note, you, under statute, and each state has different requirements here, so it's important to consider state law on this. But that, if it's in the proper form, that can be filed in court instead of a traditional complaint that has to be answered, and then discovery for 6 months minimum, and then pleading motions, and then ultimately a trial. It allows for a much simpler process for obtaining a judgment that would allow you then to go back in and retake the company or get a judgment or take action that will allow you to recover your unpaid debt. Now I see another question.
You know what? You didn't hear. I'm sorry. I was still on mute. So, Steve, go through with just a minute. What would be the process of filing a UCC1?
There's been a simplification of that process. It's surprising. It used to be almost like a document that the promisor would sign, and then you would submit that to the state offices, and then they would put it online. Now, the number of signatures there's basically an obligation when you do a document, for example, a promissory note or what we call a security agreement, which provides that this equipment, for example, will be used as collateral, that it may be retaken in the event there's a default with the underlying note. And so with that security agreement in place, then you can actually, in Utah, go online and input the parties and submit that to the state electronically in a very efficient process without a lawyer.
All right, so let's go to Valerie's comment. What about selling a client list to a company you aren't sure will handle your clients, especially if you don't want to step back in? Ooh, that's a touchy subject, isn't it?
Well, this really relates back to the first war story I identified with the dental lab, where the 30-year veteran in the dental lab business wanted to sell his clients and turn them over to a larger dental lab. And the important factor here for a seller in this situation is to really work hard to get a promissory note that, obviously your first step is to get as much of the value up front. But in fairness, the reality is that client list is questionable. You don't know when you sell that client list how many of those clients are ultimately going to be transitioned over to the buyer. And so to think that you can step away and not be involved through a smooth transition, one of the approaches I take in representing the buyer is to say, look, we need you to be active in the business, or at least available. And so in representing the buyer, I will advocate a performance section that says basically there's an assumption here that obviously there will be a 10% a year drop off from these clients. And to the extent we exceed that and only 5%, then there will be a bonus or some kind of structure where the seller is motivated to stay involved with the business, or at least not do harm. You have action and inaction that can significantly affect the success of that buyer's business. And so to think that you can just sell that client list alone is I think a troubling expectation, unless you're in an industry where there are literally thousands and maybe it's a product and I'm thinking of pest control, for example. If you got a pest control business and they don't really care who does it, that's a great way to sell a customer list and get maximum value for it right when you sell. The transition is going to be fairly smooth because there's a fairly standard service that's expected. But professionals, engineers, lawyers, I shouldn't say lawyers because they're in a category of their own for purposes of with regard to non-competes, but you take doctors and dentists. I just had an incident where a customer list of a dentist was sold for $400,000, and that client list ended up being eaten, or some of those actually were taken by the seller dentist. And we were successful in enforcing the non-compete provisions with liquidated damages, and so it created an opportunity for the buyer of that business to have recourse through the non-compete with a liquidated damages and an attorney's fee clause. Worked out very successfully. But to answer your question, it really depends on how big the client list is, whether it's professional or whether it's common customers that would be considered, whether they would easily be transitioned to the buyer.
Steve, let me ask you, would there ever be a situation where you would lease the client list rather than actually sell it?
I can't think of a situation where I've been involved with a lease, maybe leasing equipment, but leasing a client list, that would be novel to me.
I've been involved with several of them, and sometimes we lease it on a, you're allowed 3 marketing campaigns. We want to see every one of those marketing campaigns, and then you're leasing the leads basically, and I don't know. I've been involved with that. That may be an option, Valerie. But maybe not, depending, again, upon your business. Okay, Camilla's asking, I had a quitclaim deed for an investment property to a family member because of health issues, and now she's claiming it. Ooh, do I have a recourse? So it looks like he did a quitclaim deed to a family member for some reason, and now he kind of wants it back. It sounds like it was more of a gift. Steve, any suggestions?
Yeah, this is what's critical for a quitclaim deed, or for that matter, anything to do with real estate. I don't know any state that does not require such a document like that in order to be enforceable, to be notarized. Assuming it was notarized, a quitclaim is really kind of generic. There's not a lot of magic words that need to be used to make it enforceable. I would submit that a notarized quitclaim deed would be very effective and cut short any dispute if it's notarized. Now, Obviously, you got to have the proper parties and a proper legal description as well, but the essential elements of a contract and notary would probably take care of that. What you may be dealing with is a situation where there is no notary, and then you're dealing with a much stronger factual inquiry as to whether it's the actual signature and that was the intent, and those kind of questions can make it a little more difficult. But either way, arguably it would be enforceable. It depends on how easy it would be based on the formalities that were abided by.
Camille, maybe you could give us a little bit more information. The way I'm reading the question is that it looks like he gifted the property to get it out of his name for some reason, whether it was taxes or whatever, and now he really wants it back, and the family member is going, no, that's really mine. You quit claimed it to me. Talk to me about the issue of consideration in a contract. If there was no consideration given for that piece of real estate, do we really have a contract?
You know, that's a great question, Don, because as I think of the quitclaim deeds that are used, we don't often articulate the background for why a party is willing to quitclaim. And frankly, I think it opens the door to the kind of question you're raising. We frequently, almost always, throw in a clause that, for $10 or other good and valuable consideration, and we rely on that clause in a standard quitclaim deed to suggest that it's enforceable. But I think the better strategy is to try to document what the real consideration is, because it does open the door for someone to say, well, I was gifting that to you for past favors, and past consideration is not adequate consideration, and so that opens the door for an excuse or a basis for not making the contract enforceable, because consideration is a basic element of a requirement for making a contract enforceable.
For those of you that are new to the concept, if I went into a business or a contract and says, okay, look, I'm going to give you $1 million, and in exchange I want, I don't know, something, or I'm going to give you $1 million piece of property and I want something in return, for a contract to be enforceable, there should be equal and adequate consideration, and otherwise it's possible that the contract could be thrown out. Unfortunately, Camille, the way I see it is that it really looks much like a gift when you quitclaim a property and don't specify the specific reason. It appears to be a gift, and there doesn't have to be consideration given for a gift. I don't know that you have a lot of recourse on that. Steve, any comments?
Yeah, I'd be happy to take a look at that if they want to email it to me, but I would say that if they're reneging on that commitment, if there's a signed document, I think the party signing that, whether or not it's notarized, it's going to be an uphill road for them to suggest that they've changed their mind and it was not enforceable. It would take a very persuasive story, I think, because the quitclaim deeds are used so often and readily enforceable. Question is, was it recorded? If it was recorded, that would create a much stronger basis. In fact, if it's signed and notarized and it wasn't recorded, that could be a problem, because the question is, well, why was that never recorded? That may support the other side. So there's an important factual inquiry because of the failure to document the actual consideration.
There's a question, what is a quitclaim deed? When I'm transferring a piece of property, let's say I've created a trust and I want to get it out of my name and I want to put it in the name of the trust. Well, that would be, we're funding the trust, or we're funding a limited partnership, or we're funding an LLC. We're transferring title, and so what we do is we fill out a simple deed. It's not a warranty deed. It doesn't warrant that all of the debts and obligations are paid off. It's just a transfer of title. We would take that down to the county recorder or the registrar of deeds, and we change the title. That's called a quit claim deed, QUIT. Any comments on that, Steve? Is that you're the attorney?
Yeah, spot on.
Right?
That's exactly right. Very common, and there's a classic use of a quitclaim deed for purposes of funding a trust, which is different than if there is a negotiation about giving up rights to a property that frequently in the title report there will appear some kind of defect or some kind of a question, and we call these parties and say, look, you've got this bogus or this outdated claim, and we just need you to sign this quitclaim to put an end to this or put a lid on it. And so those type of formalities are very different than negotiating someone giving up rights that they otherwise really have a serious claim to. And so quitclaims are an efficient way of clearing up title issues, funding trusts, and not to conclude significant negotiations over who has rights to property.
Great. All right, Steve. Let me make a comment. It looks like we're about out of questions. If you still have questions remaining after this presentation, please write them down, or you're welcome to email us at assetfoundation.com, or Steve. His email address is still on the screen, steve@businesslawutah.com. I will tell you, let me tell our clients just a little bit of our discussion, because I was really impressed with our discussion over lunch yesterday about when to sue and when to just mediate. And I found it, Steve, to be a very, very unique attorney that's not like most ambulance chasers out there that is sue happy. I found him to be very reasonable, and if possible, he wants to mediate and talk things out. Steve, will you address that for just a minute with our clients? Because in this industry, with attorneys looking for work, that to me was a very refreshing approach. Will you discuss your ideas on mediation for a minute?
Don, thank you, because I feel after almost 30 years of trying to resolve disputes and create opportunities for clients, I have come to a point in my career after really winning the last 5 trials and last 3 appeals. I know how to win, but even when you win, it becomes such a delay. Time is money. The cost of litigation for both sides. It is so gratifying when another side is so obstreperous to win at trial and to be awarded attorney's fees. I've done that time and time again, but I've also lost emotion, and I've actually won at an appeal and then lost the client because of threats. One of my biggest cases 2 years ago was winning in the 10th Circuit Court of Appeals, and then thereafter my client was threatened with treble damages, punitive damages that were totally bogus, but he was in a foreign country and he decided he didn't even want to deal with it. So he gave up after we had won at the appellate level. We still had to, it was still further litigation, but the point is that litigation can be such a drag even if you win. And so my new mantra and passion is to offer a service of mediation that is even contingency based, or what we refer to as a hybrid. I'm willing to take the risk that if I can't help solve the problem, no fee or a lower fee or minimal fee would be paid, because I believe that if parties at each other's neck have someone neutral that will give thoughtful consideration to the merits of both sides and be candid with the parties. I mean, I've done mediations for decades, but I haven't been able to find very many mediators that are willing to speak candidly to the merits and really be driven toward a resolution, even though frequently, more often than not, I think the percentages are well above 70% success rate. And so please don't look at mediation as anything like a court or even binding arbitration. Mediation is an opportunity actually for you to learn a great deal about what the other side is thinking. So I would just urge all of you, we all have disputes, misunderstandings, or the like, and I am just absolutely convinced that a neutral party can provide some thoughtful guidance to both sides to help bring a resolution. And the parties that refuse to engage in mediation, typically, not in all cases, Don, you gave me a good example of a situation where mediation didn't make sense. But by and large, if you have a hotly disputed matter, whether it's regarding an asset purchase agreement, a business deal that went awry, changed circumstances after you do a business sale, or any kind of dispute out there, I just consistently have had a great deal of success in having a neutral authority come in and evaluate the merits and provide some guidance. And it's not like it happens the first time. In some cases, it takes 3 or 4. I went through a 2-month jury trial, and it was the 8th mediation that brought it to a close. And I still feel strongly that those 8 mediations were by far the best value in terms of helping us prepare our case as well as bringing resolution.
Steve, by no means do I have the experience that you have, but I've been involved with probably 50 different lawsuits, and I have discovered that the only ones who win in a lawsuit is the attorneys. However, I've also discovered that mediation is not a sign of weakness. But if you're going to mediate, you never do that on your own. You always have the biggest, meanest, baddest attorney that understands the games and comes at mediation from a sign of strength, knowing the law and knowing how to back the person into a corner, but willing to settle and negotiate. That has always been my strongest way to gracefully back out of lawsuits. Your experience with that?
It's interesting. My father told me that he didn't think I had it in me to be a litigator. He thought I was too nice. I think after the past 15 years, he's dramatically changed his opinion on that. My sense is that your best lawyer, your most effective lawyer, is going to be someone who is able to escalate where necessary, but to be diplomatic, respectful. Even in litigation, there are cases that if you have a very, very tough case and you think you need a big bad dog, I would make sure you have a backup plan, because that can be extremely expensive and ineffective. There's a balance, and my practice is oriented toward, when I'm representing a client, I want to structure it in a way where I build rapport with opposing counsel as much as I can, but when they take a strong adversarial position, I want to be prepared to be aggressive, assertive, and and achieve results. And that has been our history for the past 5 trials and appeals. We go after people that are unwilling to be reasonable. And how do you define what is reasonable? That's why mediation is so valuable, is to assess who's being a bully and who's being reasonable.
Okay, one last question. And Steve, they were asking if you were admitted in Texas. My guess is you would, and I replied back, you're admitted in New York, Pennsylvania, and Utah, but that doesn't mean that you couldn't serve as a consulting counsel in any state. Is that right? Or
certainly, yes.
Or how would you work that?
Certainly for mediation or for transactional work. The issue is if there's a state law question that requires local Texas court action, then I would be using co-counsel. I would be co-counsel, but I have cases in New Jersey. I have cases in other states, and in federal court, it's much easier to practice in any state in the nation. When you're dealing with state court issues, then it becomes more difficult. But for a large case, even in state court, there can be an admission process that would justify if you have a certain expertise that you like in a lawyer that's admitted in another state. It may be that you want to use that lawyer. That is very possible. So you can blend. There are some options there that don't preclude or exclude using counsel from another state that's not admitted.
Steve, this has been wonderful. I appreciate your integrity. I appreciate your forthright answers. Most of all, I appreciate just the reasonable approach to litigation, and your expertise on the subject. Your contact information is still on the screen. It's 801-375-2830. Or you can contact Asset Foundation at 1-800-276-1430, and we're happy to refer. But thank you for the information tonight, and thank you all for being on. We know on the East Coast it's getting a little late. We promised we wouldn't go longer than 90 minutes, and I think we're at 84 right now, so we wish you all the very, very best. Steve, any parting comments before you close?
If anyone would like to engage, feel free to call or email. The one parting comment I have is seek an outside opinion if you got a tough question, whether it's me or someone else. But I just am amazed at how some people dig in their heels, take a position, and there just are so many creative ways of solving problems. And it's been my experience that a license to practice law can be used effectively to balance the parties' interests and come to a meaningful resolution that will minimize the pain for both sides. But the ultimate and the first step is to get it properly documented first, as we talked about in this session, and hopefully problems don't occur, but inevitably they do. With the larger the transaction, the more likely. But it's really been a pleasure, Don. Thank you for the invitation and the opportunity.
Thank you, everyone, for being on. Steve, special thanks for you, and we bid you all adieu. We will have a webinar next week, and in fact every single week for the next 4 weeks leading up to our Chicago event. So thank you for being here. Have a great evening. Good night.